Folks, we're back. Today, we're going to be looking at federal employment law. Let's get started. So, besides wage and hour law, there are two more significant federal statutes that place considerable responsibilities on employers. There are also considerable protections for funeral directors and other employees of a firm or applicants to employment. Whether you are a funeral director or owner, it is important to know these rules and how they affect the employment relationship. Every employer has something different. So my primary institution, my full-time place of instruction, Miami-Dade College, students have Students' Rights and Responsibilities Handbook in the College Catalog. State University of New York, you have a Student Rights and Responsibilities Handbook and a College Catalog for certain. Faculty, here in Miami, we have our employment contract, which is done through our collective bargaining agent, United Faculty Miami-Dade College. It's a union. And then our employee handbook. All of these are outline rules, regulations, whatever, for compliance with work practices and state and federal guidelines. Well, we reviewed how the American Disabilities Act affects us as businesses back in Chapter 9. Now we look at how it affects us in working relationships. So to have the American with Disabilities Act applicable, a funeral home must have 15 or more employees. Funeral homes with less than 15 employees are exempt for employee-related stipulations. We generate how many employees we generally employ, 15 or more for each working day, in each of 20 or more calendar weeks in the current or preceding year. We generate how many employees we generally employ, 15 employees for each working day in each of the 20 or more calendar weeks. So if you are given some sort of computation problem, this would be fairly difficult, I think, to accomplish on a professional or a classroom examination. But look for the trigger. Are you employing at least 15 employees for at least 20 weeks? And then you should, boom, have it down pat. And this includes everybody, full-time, part-time, and casual, which we would consider something like on-call. Our part-time employees are regular employees. Many of you work part-time jobs. You have at least 20 hours a week. And then we have the casual as needed, which would be our associates we call in for funerals. They can work when they can, but are not obligated to work a shift. Make detailed examinations of your work schedule to ensure compliance. Purpose of the Act is to prohibit employers from discriminating against disabled individuals in all phases of the employment relationship: application, testing, hiring, advancement, discharge, compensation, and job training. This does not mean an individual with a disability is given preference over those without disabilities. ADA does not establish quotas or any sort of hiring guidelines you must have. It only prevents you from considering the disability and making certain employment decisions. It protects qualified individuals with a disability, hereafter called quids. To be a quid, the employee must be able to perform the essential functions of the job with or without reasonable accommodations. The ADA requires employers to provide reasonable accommodations unless to do so would constitute an undue hardship. Now you can imagine you're going to argue that. People are going to argue that. It is very subjective. The Equal Employment Opportunity Commission does give some guidance, but in most cases the precise scope is decided on a case-by-case basis. There are some obvious things. If you are looking for a removal agent and a person walks in, and they do not have any upper extremities, they have no upper extremities whatsoever, it is going to be fairly hard to determine any reasonable accommodation so that that individual can perform the essential function of the job of moving bodies. The person comes in and says that they have problems standing up for large periods, and you are hiring for a clerical worker whose primary duties are sit down, but on occasion help unload a casket or whatever. First says, after I help someone move something heavy, I usually have to rest for 10 or 15 minutes because of my back. Well, Is it a reasonable accommodation that after someone helps move some chemical boxes, they get 15 minutes just to work at their desk so that their back doesn't go out on them? That would be reasonable. So apply some common sense. Apply some common sense. A disability is any physical or mental impairment that substantially limits one or more life activities, a record of having an impairment, or being regarded as having it. So it doesn't just cover people that have an impairment. People that have had an impairment, even if it may have been corrected, can be considered to have a disability. Or even people who are just regarded as having that disability are covered. Examples of everything. The clinical term mental retardation, okay? Organic brain syndrome, emotional or mental illness, special learning disabilities, orthopedic visual, speech, and hearing impairment. Look at all this stuff. HIV infection, muscular dystrophy, epilepsy, drug addiction, alcoholism, cosmetic disfigurement. Look at all the things that are covered because they are either a physical or mental impairment that limit substantially one or more life activities, a record of having an impairment, something like maybe drug addiction, or being regarded as having an impairment, being a diabetic. You might not have a severe diabetes problem, but you've been able to keep it in control with diet, etc. But it's still there. So even though drug addiction and alcoholism is listed, current abusers are not protected. If you are still abusing, you are not covered by ADA. It also does not include homosexuality or bisexuality, gender identity disorders, sexual behavior disorders, compulsive gambling, kleptomania, or pyromania. All the fun stuff in life. Okay? 2 steps in determining whether an individual is a qualified individual with disability. Determine the individual has the prerequisites for the position to be filled. First of all, determine do they meet what you need. Requisite education, requisite experience, etc., etc., etc. Okay? Determine if the individual can perform the functions of the position with or without reasonable accommodation. And those steps must be made at the time the employer is making the employment decision. You cannot speculate for the future. Okay? You cannot speculate the risk of them becoming disabled or potential increase in health insurance costs. You have to ask yourself, do they meet the prerequisites? And if they meet the prerequisites, can they perform the essential functions with or without a reasonable accommodation? So it's important that you know what the essential functions of a job are so they can be discussed. The EEOC does not define the functions for each of the hundreds and hundreds of occupations that exist. It's going to look to your judgment as to what functions of the particular job are necessary. In order to be considered as evidence, it has to be in writing. Well, duh, you should have had that when you've advertised, right? The list must be prepared in writing prior to the advertising of the job opening or the interviewing of the job candidate. You can't interview them and then surprise them with the list later. Generally, essential functions are job duties that are fundamental and not marginal. Factors to be considered, and it sneezes all the sort of stuff up here for you. It's common sense. Really is. What is the importance of what you are requesting to the job you're hiring? A person being able to lift heavy objects, drive long distances, and work irregular hours would clearly be essential functions for a removal technician. Them being able to paint buildings or assist with lawn maintenance would be marginal. You should not be hiring removal techs to mow your lawns. Okay? You should not be using your removal techs, in many cases, to do clerical work. But you will want them to have phone skills and good communication skills because they're going to be interacting with members of the public and other professionals in their duties. During interviewing, the employer should provide the applicant the written list and ask if the applicant whether he or she can perform each of the essential functions with or without a reasonable accommodation. Generally, it is usually the responsibility of the applicant or disabled employee to inform the employer an accommodation is needed. If they do not tell you that an accommodation is needed, they cannot surprise you with it later, which is why you want all of this in writing. Once the employer knows an accommodation is needed, the two parties need to determine what are the precise job-related limitations imposed by the disability, how can they be overcome, and what potential accommodations are available, and what will be their effectiveness in enabling the individual to perform the essential functions of the job And obviously, what is their accommodation preference? What would you like to have? Here are the options available. Which one would you like, and can we really do that? It is impossible to go over every possible accommodation. It gives you all this stuff in the book. I'm not going to cover all of it, but you can see it's substantial. It is important you understand that a reasonable accommodation need not be the best accommodation, but only meet the job-related needs. Okay? The employer is generally not required to provide a disabled employee with accommodations that are primarily for the personal benefit of the disabled individual, such as one that assists the individual throughout daily activities, both on and off the job. So, for instance, if the gentleman shows up with no arms and he wants to be a removal tech, he says, oh, you got to buy me two $30,000 prosthetics, and I need to be able to take those home at night. Yeah, not so much. If it is not an I don't know how $60,000 worth of prosthetics would be considered reasonable for you, but okay. Say you went through with that. He would not be entitled to take them home to improve his quality of life outside of the area. Okay? Those are for work purposes. If you give someone a specific wheelchair or seat at work, they're not entitled to take that home with them, etc. Failure to provide an accommodation may be justified where the employer can demonstrate that the accommodation impose an undue hardship on the operation of the business. It must require more than a minimal expense. It uses the Latin term de minimis, okay? Minimal expense or inconvenience. So, person says, oh, you know what? I really can't do this job unless I have a pair of readers. Do you guys keep readers around the office in case, eyes get tired and need something? What are a pair of readers at your big box retail store preference? Like $10 for a pack of like 100? Yeah, that's a minimal expense, keeping a couple pair of readers lying around the desk. Person wants like, a scanning electron microscope to look at signatures. Several $100,000, not likely. All cases are decided case-by-case basis. What is unreasonable for a small employer may not be undue or unreasonable for a large employer. Okay? 11 factors. And you're going to see that these 11 factors look an awful lot like some of the factors we studied back in Chapter 9. Nature and cost of accommodation, financial resources of the facility, number of people at facility, effect of reasonable accommodation on expenses and resources, impact on accommodation on the operation of the business, overall resources of the employer, size of the employer's business with respect to number of employees, all sorts of good stuff. The concept also takes into account any substantial or disruptive interference caused by accommodation. So, for instance, book gives you a pretty good one. Person is chronically cold. Says, I usually have to keep temperatures at like 92 degrees in the house so I can feel comfortable. Chances are the rest of us don't want to be locked in an 8-hour shift in a room at 92 degrees. That's just like world of suck right there, man. So, yeah, that would have an impact on everybody else. Passed American Disabilities Act. Another good one you can get in trouble with. Civil Rights Act 1964, Title VII, prohibits possible discrimination in employment based on race, color, religion, sex, or national origin. 78, it was amended to include pregnancy. It was further amended to prohibit age discrimination and applies to those 40 years of age or older. Yay, I'm protected. What does it take to be covered by the Civil Rights, Title VII of the Civil Rights Act? Well, first of all, 15 or more employees. We've seen American Disabilities Act parrots that. Magic number is 15, okay? Now, age discrimination in employment is restricted to 20. You have to be a larger business, okay? That's the exception. ADEA, American or Age Discrimination in Employment Act, is restricted to 20 or more. And it's the same method for determining how many employees, part-time, full-time, casual, within the same number of work weeks, okay? 15 or more, 20 more, whatever it is, within the 20 work weeks, boom. While you may not fall under the federal civil rights statute, 45 states have said, oh, that's a good place to start. Let's evolve this a little and made it harder. Most of the state laws cover all employees in the state, but there may be some exceptions. So prior to 1991, you could state that an impermissible factor had entered into an employment decision and the same decision would have been made based on other permissible factors, and no violation occurred. Oh, he's such a nice colored boy. Really? Really? Okay. Wow. Bam. Well, that came into consideration. It's prior to 1991. No one cares. You were hired. It is what it is. However, after 1991, if there is any discriminatory motive whatsoever, violation has taken place. You know, I really don't want to have any more girls in the office. Woohoo! Winner, okay? It is vital to institute safeguards against impermissible motives becoming part of employment-related decisions. This is especially true during hiring. The representative of the employer must be trained to avoid any discussion of prohibited topics. Decisions regarding promotions, compensation, benefits, discipline, discharges must also be made in compliance with the Civil Rights Act. Thoroughly document all employment-related decisions so that there is a written record of why and how the decision was made. Lots of things get to court. Okay, lots of things get to court. And the first thing the court looks at is the written evidence and documentation, and then starts looking at affidavits and external situations. That is important. Title VII is enforced by the EEOC. Okay, all employees must file a claim through the EEOC and go through a two-step process. First is mediation, second is enforcement. Generally, okay, the charge must be filed in 6 months of the violation. If you wait for it to hatch, you run the statute of limitations on it. The EEOC informs the employer of the charge. Investigator interviews the employer and any witnesses for the employer. Investigator may do an on-site tour as well as interviews. Employers will also generally be requested to produce payroll, timesheets, etc. Within 120 days after the charge is filed, EEOC will make a determination of cause or no cause. If no cause, the case is dismissed. Complainant receives a right to sue letter, has 90 days to file a private suit in federal. Then they will have to meet evidentiary purposes and prove what they're saying. If cause, they attempt to work out a settlement. If this doesn't work, then either the EEOC or employee can bring suit in federal court. So if they find reason that there was to mediate the situation, not bring it to court any more than it has to, and if it simply cannot get you to agree to something, the EEOC can choose to sue you, or the employee can choose to sue you. Because of broad powers, the EEOC, it is important to maintain paper trails. They require all employers to maintain for at least 6 months after any personnel action all records related to the action. It is generally recommended you keep records for 3 years. Nowadays, honestly, with the advent of and secure servers, I see no reason why you can't just scan it and then store it so you have it retained inevitably. Folks, thank you for your attention. We will see you next time.